believe we've had our tea. So those who are still out, I request that we find our way in, because we are a bit behind schedule and we need to save some time. From the program, I just want to give a quick recap of the fourth colloquium, a recap of the fourth colloquium, challenges and achievements. So I'll not take a lot of your time, because I know you want to hear more from our resource persons and from the facilitators. So I'll not take a lot of our time. But as the Secretary General, allow me first to, on behalf of the President and the Council, of course, to acknowledge our delegates. So I'll be calling out your country, your organization, your parliament, and wherever you are, please feel free to wave in the air so that we appreciate and acknowledge your presence. First, allow me to acknowledge the presence of the delegations from Cameroon. Cameroon, are we here? Cameroon? I hope they must be having tea somewhere. I'm not seeing them. Okay. The Republic of Gambia, I'm sure he's here. Thank you, Saloon. Swaziland? Swaziland, did we change the name? That one. Eswatini. Good, welcome. Republic of Zambia, Zambia. There we are. Thank you. Thank you. The Republic of Zimbabwe, of course, the Vice President has just done great things there. Zimbabwe, here we are. Thank you, thank you. And for the record, Zimbabwe, one of the council members, the one representing the southern region, Ms. Elizabeth Hove, was elected to represent the southern region in the council, the colloquium, but of course she sent her apologies. Republic of Uganda, Uganda, thank you. Republic of Kenya, thank you, thank you. Republic of South Africa, South Africa, thank you, thank you. Ghana, thank you. Again, just to let us know that the council member from the Western region, West Africa region, is from Ghana. That is Eric, but again, he was not able to join us. I think he's gone for another assignment. Then Republic of Nigeria. Nigeria. Okay, hopefully they'll join us, because I know from the registration we have. Then allow me also to acknowledge the presence of our other regional parliaments. We start with East African Legislative Assembly. East Africa Legislative. The man is walking majestically at the back. That is Dennis. And there were two. Okay, Dennis is there. Then ECOWAS. Thank you. We have ECOWAS here. Of course, SADC sent apology. I think they're having sessions ongoing, so they are not able to join us this morning. Am I forgetting? Of course. Yes. No, I'm coming there. Okay. Someone wants to finish me, but I'm coming there. Then I think our host PAP, of course, where we are, so they are with us here. We acknowledge them. I was forgetting the United Republic of Tanzania, and especially the Parliament of Zanzibar, who is also, Musa is one of the council members. So I think just escaped my mind. I was seeing you more as the council then. But welcome, karibu sana, Musa and brother. Good. Have I left out anyone else apart from our sponsors? Before I go to our sponsors. Malawi. Malawi, the Republic of Malawi. Good. There we have two delegates. I must make sure that this list is complete. Okay. Am I forgetting anybody else? I don't want to be cited for contempt of parliament. Am I forgetting anyone else? No. Now, besides that, allow me also to acknowledge the presence of, I'll use the acronym ADA. Where are we? Our delegates from ADA. Here we are. Good. Of course, we also have LexisNexis. I don't know if they're here, but I've seen Takisha and the team outside. Center for Human Rights, Pretoria. Have they come? Okay, hopefully they'll join us in the course of the sessions. Now, delegates, allow me to first of all give the following announcements. Now, in your folder, of course, you've already seen you have the program. We have the Colloquium Constitution, and in that Colloquium Constitution, if you look at the first schedule, at the back, we have the Nairobi Principles. These are principles that were developed by legal counsel who attended the first colloquium in Nairobi. And since it was in Nairobi, that's why we gave them those names, Nairobi Principles. So if you look at the back, you will see the Nairobi Principles as part of the Constitution. And this is the Constitution that is guiding the colloquium, and I'll be making some announcements towards that shortly. Secondly, you also have our election rules, the election rules of the African Colloquium of Legal Counsel to Parliament. So you also have that set of election rules, so you need to be familiarizing yourself with them. Of course, you have the program with you, and of course that nice bag courtesy of Pan-African Parliament. Having said that, allow me to make a communication. Now that we are in Parliament, we talk of communications and all that. So I'm not going to make communication from the chair, but I'll make my communication from here. I think you have it in your, do we have it in the folder, Sheriff Sam, the communication? Yes, just a slight correction that I'll be making. Dear delegates, as you may be aware, the term of the chairperson and members to the colloquium is coming to an end. And as per the program, as you can see from the program, we are scheduled to hold the annual general meeting of the Colloquium on Thursday, 31st October 2019, during which an election shall be held for the new council members. Delegates are expected to, 1, elect the president, and the current president, of course, you've seen her here, Madam Suraya. I won't say much for now. Then we also have other council members. The council members are elected from regions. So I think there's a region missing there. The first region there is Southern African region. The Southern region is missing there, so please just insert that. I think it was an oversight. The current representative, I think, is Ms. Hove from Zimbabwe. So their position is up for grab. So those from those regions, you can start thinking through who you will be nominating to vie for the position this Thursday. We have the Western Africa region, which again, if I can just draw your attention, if you look at the Constitution, I think the Constitution has a part where the regions are listed. Then which page is it? The Constitution, I think the regions are listed. Have you seen it? Page? Page 10. Oh, is it the... Now you can't see the next page. At the back, oh yes, at the back. Page 39. At the back. If you look at the back, you'll see the regions and the countries that are falling under those regions. So allow me to start again. Southern African region, we have Angola, Botswana, Lesotho, Malawi, Mozambique, Namibia, South Africa, Swaziland, Zambia, and Zimbabwe. Then we have the Western African region. The Western African region, we have Benin, Burkina Faso, Cape Verde, Cote d'Ivoire, Gambia, Ghana, Guinea, Guinea-Bissau, Liberia, Mali, Mauritania, Niger, Nigeria, Senegal, Sierra Leone, and Togo. The current representative for the Western African region is Eric Owusu-Mensah from the Parliament of Ghana. Then we have the Central Africa region. The Central Africa region, I'm not seeing the Central Africa region here. Secretary. Page 38. Oh, my page 38 is, oh, okay. I think there's a printing error. Okay, the Central Africa region, we have Central African Republic, Cameroon, Chad, Congo, Democratic Republic of Congo, Equatorial Guinea, Gabon, Sao Tome and Principe. Is that how they pronounce it? Okay, that's an Africanization program. Okay, then we have the Eastern African region, where we have Eritrea, Ethiopia, Somalia, Djibouti, South Sudan, Uganda, Kenya, Tanzania, Rwanda, Burundi, and the Comoros, Mauritius, the Seychelles, and Madagascar. Northern African region, of course, we have Sudan, Egypt, Libya, Tunisia, Mauritania, Algeria, and Morocco. Then we have the regional parliaments. Regional parliaments, we have the South African Legislative Assembly, we have the Pan-African Parliament, we have the ECOWAS, and we have SADC. Now, these regional parliaments also elect representatives to sit in the council. So, dear honorable delegates, this is therefore to invite all interested persons to submit their nominations for the various positions by completing the nomination form. The nomination form is available at the registration desk out there. The colloquium election rules that guide the nomination and election process and reference are also available in your folder and in case it's missing in your folder, you can access it at the registration desk. So please fill in the forms and return them to the Secretariat desk, the Secretary General, but at the Secretariat desk. You can email the nomination, complete the nomination form at africa.colloquium@parliament.go.ke, or by delivering the nomination form to the Secretary General. Of course, he will not be seated at the registration desk, but the officers there, so you can deliver it there. Note this, nominations shall be received by Wednesday, 30th October 2019 at 13:00 hours, South African time. Okay? That is tomorrow at 1 p.m. So please, the various regions represented here, you can start conversing, discussing, and seeing who you think can ably represent your region. But in addition, also we need a president. So again, if you have the call, the vision of the colloquium, and especially after those inspiring opening remarks from the Vice President of PAP, I think everyone should be running to vie for the position of president. So I'm waiting for enough, I'm looking forward to receive enough nominations. Thank you. Any question on the elections? So please, let's work on that. Now, in just 5 minutes, delegates, allow me to take only 5 minutes to recap just a few challenges and issues that have emerged from the fourth colloquium. Then after that, I'll hand over the mic for the next presentation on litigation challenge and best practice. Delegates, our last colloquium was held in Kampala, Uganda. And for those who are there, how many attended the Uganda colloquium? Wow, wow. Now, next time, I'll pray that you bring more of your colleagues to the colloquium, but allow me to sincerely thank all of you for finding time to come again to this colloquium here. So we had our last colloquium in Uganda. Before that, remember the colloquium, we had held 3 other colloquia in Nairobi, Kenya, Nairobi and Mombasa, but generally in Kenya. Then the 4th one was in Uganda. That, again, was the first time that the colloquium was moving out out of Kenya, and it was such a great success. I think in the last colloquium, the attendance was standing at about 100 delegates. This time, we are slightly low and in numbers, but I'll explain the reasons why. So that 4th colloquium, remember, it is at that 4th colloquium that we finalized, the delegates approved the final constitution of the colloquium, which you now have. So that constitution was adopted in the last AGM. And remember, in that AGM, we had some amendments, which the council, the incoming council then, led by President Zuraya, of course, took over, and they were able to see to it that the constitution and the amendments that were proposed are finalized and completed. The constitution has been translated. The constitution and the election rules were also fully adopted in the Kampala conference, and so you have those 2 sets of documents as approved by delegates in that meeting, and so you can have a look at them. Now, the election rules and the constitution, together with the Nairobi Principles, have also been translated into French. We have translation into Swahili, isn't it, Musa? Yeah. So for those who also understand and love Swahili, the document is also available in Swahili. Now, there's a joke that goes around in the East African region that Swahili was born in Tanzania, it fell sick in Kenya, it died in Uganda, and it was buried in the Democratic Republic of Congo. So if you want to know why, come and I'll explain to you. So they are available in Swahili. I think, Clement, do you have it in French? Or rather we also to translate it in Spanish and Arabic, and we're in the process of doing that. So that's a big, and Portuguese, sorry. That's a big, big achievement that this council has been able to facilitate. Secondly, of course, as you can see, the council has worked very hard to make sure that we have this colloquium. We had reached a point that we actually wanted to postpone the colloquium because there are so many challenges in terms of hosting and all that. But by the grace of God, of course, PAP came through and were able to host this colloquium. And so again, we've had the colloquium successfully held without fail outside Nairobi again for the second time. And we are now, rather for the second time outside Nairobi, and we are looking, we hope that by the end of this session, we'll have other volunteers to host the 6th colloquium. So you should also start thinking of if and when you are going to invite us to bring the colloquium to your parliament. But I must not forget, and again appreciate the Vice President of PAP, and of course PAP as a whole, for agreeing to sponsor an annual meeting for legal counsel. So that will give us another opportunity to be meeting before the colloquium. Remember, the colloquium is a biannual event. The other aspect, of course, that we are working towards is that if you look at the Constitution, we are required to be paying some registration fees and all that. We couldn't effect that now, but this should be up and running probably from January next year, where we'll be expecting your parliament to start paying some subscription so that the colloquium can stand on its own. This was held back because of the registration of the colloquium. We are at the tail end, and we are certain that come the end of this year, the colloquium will be duly registered, and we'll be able to have all those frameworks and structures on the ground so that we can facilitate the colloquium to move to the next level. Members, the challenges we have faced as I wind up, one is the ability to identify the host of the colloquium early. It's been a challenge. I think because of the budgetary aspect, quite a number of parliaments, and you agree, have not been able to come forth to host the colloquium for reasons that as a baby that was born as growing up, we expect a lot of support from the host parliament. And most of our parliaments financially, and our countries generally financially, they have gone through some lean times, and that has made it a bit difficult to get a host. Moving forward, we hope that once the colloquium is registered, we'll be able to engage even with the partners who will be willing to sponsor the colloquium directly, and so that we can actually host our activities in whichever place. As long as you are ready to invite us, the colloquium then can take care of the rest of the cost, and then we'll be able to move forward. So that has been a challenge, but the registration will come to pass soon. The other challenge we've had, of course, is attendance and participation by parliaments and legal counsel generally. Having served in parliament and engaged with a lot of us who work in parliament, there is a general lull towards appreciating the role of legal counsel in Parliament, and I think this is a challenge that we are facing across board, and it will only take the colloquium to take a bold step, as was mentioned earlier, to try and convince our parliaments to appreciate the role of the legal counsel and to implement the Nairobi Principles. So moving forward, as the new council will be coming in, they must come up with the strategies on how to sell out the Nairobi Principles and talk to our leadership, probably hold on to PAP as the big brother and see how the colloquium can be buttressed and have support in PAP so that we are able to be facilitated across times. The attendance also has been affected. This year especially, the numbers are slightly low for obvious reasons, and I think this is something that was in the common knowledge. When we were already planning for the colloquium, the xenophobic attacks that took place actually affected a lot of participation. We had a number who had confirmed attending, but for some reason they just decided that they felt that they were not going to be very secure. We have quite a long list, and they had to withdraw the last minute. Of course, most of us, we were walking by faith. I don't know which faith, but for me, by faith. And we knew that these were just some challenges, and we had to come forth and continue planning the colloquium by faith. The president can attest to that. And so that's why we've had you here, because you're also here by faith. You knew that by this time, probably these matters, the government will have addressed it, and so here we are. But quite a good number of countries were not able to come because of those fears. And I'm sure even back from your countries, your clerks were still not sure that they wanted to release you. In one particular country, they said, if I release you, it's because I hate you, I want you to go and die there. But on a light note. But I think that was a big, big challenge, because it meant that the confirmations came in very, very late, and the letters, invitation letters also went out very, very late, and a number of countries and parliaments were not able to release their officers at this time. So moving forward, I think we'll be able to plan early and also be able to have adequate information and of course deal with the issues of attendance early. You remember, for those who are there for, was it the second colloquium or the third colloquium? Second colloquium. I think when the second colloquium was being organized in Nairobi, there was a terror attack in Nairobi, and quite a number of participants had already confirmed. But after the terror attack, I think it happened 3 or so weeks to, or a month to the colloquium, so many people pulled out because they were not sure of their security. And Madam President was one of those who pulled out. So you get the point. So some of these things, they normally create some fears and all that. So I think we need to acknowledge that and know that some of these things might affect attendance, but we are grateful that we are here now. Last but not least, in terms of attendance, again, is a challenge we faced, is a number of parliaments still don't have budget lines for legal counsel to attend this colloquium. And I think if the new council, when they take over, if we can have a situation where we know the next host early enough, then this communication is sent to parliaments, then parliaments can budget early enough for the members to participate in the next colloquium. Like now we know the next colloquium, apart from the annual meeting that has been supported by the Vice President, the next colloquium will be in those who went to school and did mathematics, 2021. So the next colloquium will be in 2021. So we can start planning and budgeting for it so that when the time comes, you won't have challenges. With those very many remarks, I've been given a red card. My time is up. If you have any questions, come and ask at the back. Thank you and welcome.
Good morning, colleagues, and everyone in the chamber. Before I start, may I please request that Mr. Sharif Wenda and Mr. Solomon Kurunda move to the front, please. Thank you very much. Once again, colleagues, good morning. My name is Nat Mchenglane. I'm a legal advisor at the Parliament of the Republic of South Africa. I work in the litigation unit in our department, Legal Services Department in Parliament. And for this reason, I've been requested kindly by the Colloquium members to come and moderate this session. A special greetings to the Vice President of the Pan-African Parliament and the President of the Colloquium. The area that I'm moderating today is the litigation challenge. Litigation challenge, best practice, and a discourse. That is our topic for an hour. I'm under strict instructions that I must moderate this within an hour because we are really out of time. But I'm excited to present this because, you know, I'm talking to mostly lawyers in this room, and I expect it to be the most robust of all of the discussions here today. And talking about robust, parliaments generally should be very robust institutions where there is debate between those represented in parliament or those representing people in parliament. But the nature of this robust debate is proof of what we call participatory democracy in South Africa, that people are participating through their representatives in parliament. And the weapon of choice in this robustness should be debate, where parties influence each other in order to find agreement in good faith and in mutual trust. You know, this is under ideal circumstances, but practice has been slightly different. Debates have not necessarily all the time led to mutual agreement, good faith, and persuasion. You know, convincing one another not to leave the chamber, but discuss and agree with within the chamber on all of the matters being debated. Instead, what we've seen is a developing challenge of litigation that arises out of matters taking place within parliaments. So this weapon of choice is slightly being challenged by litigation. And this litigation has mostly come from lack of agreement within matters being raised in the chambers, in our parliaments. This has been most prevalent in South Africa in the past 5 years. My colleagues from the country can attest to a number of cases that have gone before the Constitutional Court where Parliament was being successfully challenged. And I can remember up to 5 times for having failed to agree within the chambers of what should pertain. There's a few cases, for instance, as the Vice President has mentioned, where people have felt that the laws do not represent their interests, or people have not been properly consulted by Parliament when it passed the laws. We can count a number of them, and all of them have been decided against Parliament and provincial legislatures. But I will not take up much of your time, because this, to speak about these matters is not my responsibility. It's the responsibility of my able colleagues behind me, and therefore I'll move ahead and introduce them. It is Mr. Sharif Wenda over here, and I will just read his brief bio. He holds a Bachelor of Laws degree from the University of Nairobi, Kenya. He has a Master's of Laws degree from the same university. He holds a postgraduate diploma in laws from the Kenya School of Law. He holds various, not just one, various certificates in legislative drafting. He is an advocate of the High Court in Kenya. He was admitted as far back as 2002. He serves as a he has served in the past as a senior resident magistrate in Kenya from 2005 to 2009. He is legal counsel to Parliament of Kenya since 2009 up to 2013, and currently he is the Deputy Director, Litigation and Compliance for the Parliament of Kenya since 2013 up to thus far. That is Mr. Muwenda. However, in the interest of time, I'll also introduce my second speaker, which is Mr. Solomon Kurunda. He is a principal legal counsel for the Parliament of Uganda. He has served in this position since 2007. He has experience in drafting of bills, motions, petitions, and has represented Parliament since Parliamentary Service Commission in the courts of law. He has a Master's of Laws degree from the University of the Western Cape, here within our shores, southwards in Cape Town. He is an admitted advocate of the High Court of the Republic of Uganda. He's a Commissioner of Oaths and a Notary Public. So without any undue delays, I'll invite you, my colleagues, to please clap your hands and welcome our speakers today.
Thank you very much. Dear colleagues, participants, it's my pleasure to be here to discuss this issue on litigation affecting Parliament with you. I want to start first with a very short clip. Please, you can follow it from the screen.
This was not a normal prorogation in the run-up to a Queen's
Increase volume, please.
It prevented Parliament from carrying out its constitutional role for 5 out of the possible 8 weeks between the end of the summer recess and exit day on the 31st of October. Proroguing Parliament is quite different from Parliament going into recess. While Parliament is prorogued, neither House can meet, debate, or pass legislation. Neither House can debate government policy, nor may members ask written or oral questions of ministers or meet and take evidence in committees. In general, bills which have not yet completed all their stages are lost and will have to start again from scratch after the Queen's speech. During a recess, on the other hand, the House does not sit, but parliamentary business can otherwise continue as usual. This prolonged suspension of parliamentary democracy took place in quite exceptional circumstances. The fundamental change, which was due to take place in the Constitution of the United Kingdom on the 31st of October. Parliament, and in particular the House of Commons, as the elected representatives of the people, has a right to a voice in how that change comes about. The effect on the fundamentals of our democracy was extreme. No justification for taking action with such an extreme effect has been put before the court. The only evidence of why it was taken is the memorandum from Nicky da Costa of 15th August. This explains why holding the Queen's speech to open a new session of Parliament on the 14th of October would be desirable. It does not explain why it was necessary to bring parliamentary business to a halt for 5 weeks before that, when the normal period necessary to prepare for a Queen's speech is 4 to 6 days. It does not discuss the difference between prorogation and recess. It does not discuss the impact of prorogation on the special procedures for scrutinising the delegated legislation necessary to achieve an orderly withdrawal from the European Union, with or without a withdrawal agreement, on the 31st of October. It does not discuss what parliamentary time would be needed to secure parliamentary approval for any new withdrawal agreement as required by Section 13 of the European Union Withdrawal Act 2018. The court is bound to conclude, therefore, that the decision to advise Her Majesty to prorogue Parliament was unlawful because it had the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. The next and final question, therefore, is what the legal effect of that finding is, and therefore what remedies the court should grant. The court can certainly declare that the advice was unlawful. The Inner House went further and declared that any prorogation resulting from it was null and of no effect. The government argues that the Inner House could not do that because the prorogation was a, quote, proceeding in Parliament, end quote, which, under the Bill of Rights of 1688, cannot be impugned or questioned in any court. But it is quite clear that the prorogation is not a proceeding in Parliament. It takes place in the House of Lords chamber, in the presence of members of both houses, but it is not their decision. It is something which has been imposed upon them from outside. It is not something on which members can speak or vote. It is not the core or essential business of Parliament which the Bill of Rights protects. Quite the reverse. It brings that core or essential business to an end. This court has already concluded that the Prime Minister's advice to Her Majesty was unlawful, void, and of no effect. This means that the order in Council to which it led was also unlawful, void, and of no effect, and should be quashed. This means that when the Royal Commissioners walked into the House of Lords, it was as if they had walked in with a blank sheet of paper. The prorogation was also void and of no effect. Parliament has not been prorogued. This is the unanimous judgment of all 11 justices. It is for Parliament, and in particular the Speaker and the Lord Speaker, to decide what to do next. Unless there is some parliamentary rule of which we are unaware, they can take immediate steps to enable each House to meet as soon as possible. It is not clear to us that any step is needed from the Prime Minister, but if it is, the Court is pleased that his counsel have told the Court that he will take all necessary steps to comply with the terms of any declaration made by this Court.
Thank you very much. Colleagues, maybe for the benefit of those who have not followed that discussion in British exit, what happened immediately after that ruling, I think I want to read that part. When Parliament resumed on the following day, the prorogation ceremony was expunged from the journal of the House of Commons, and business continued as if the ceremony had never happened. And that is the role of the courts generally and in many jurisdictions. And this is affecting a lot of our business. I don't know, in the jurisdiction you come from, what is the implication? That is my long presentation. I don't want to go through it. I want to cover part of it so that I can open the floor for discussion. But I want to start by saying, you can move, yes, that is the outline. I think it will be available on email. You can look at it later. Move to the next slide, please. That is what the Council in the Litigation Directorate in the Parliament of Kenya do. Generally, we cover what the Vice President was saying, advisory. And I think you have heard what the lady speaking there is the President of the Supreme Court in the UK. That matter had originated from the High Court. It went all the way to the Court of Appeal, and it was consolidated by another court from Scotland. And that pronouncement has a big impact on what is happening now. I'm sure in your jurisdictions you have also suffered the same. I think you have heard from our leadership, Justice Hall. She said the advice by the Prime Minister to the Queen was null and void. So if it was advice from you, I'm sure what the Vice President said, you will be free in going home because you have no job. You have advised the Queen, And as a result of that device, the House, the decision has been challenged at the highest court and been declared unconstitutional and lawful. So I think I want to start from there. The role of the legal counsel, and I think I will be coming back to the discussion that our chief guest has introduced. The role of the legal counsel is being challenged in many jurisdictions. I will give a synopsis of what is happening in Kenya, in South Africa, a bit of it, and Uganda, in one slide or two slides. But I think the bigger question is, and I think the Vice President has alluded to this, are our parliament passing laws, or are laws passing through parliament? That is a very important discussion, because we could be a very efficient, we can become like a panel board. But what are we doing in our legislatures? Because you find that, I think the Vice President alluded also to that, when the majority leader in your parliament or the leader of government business comes with another paper, it is like it is in blue, it is white and clear that has to see the end. Even the public participation in some jurisdiction, I've read many cases from India, many African continent. You find that public participation has just become like a process. You don't even give the public opportunity. And there are many cases when you look at my presentation. But what is ailing us? One, you can move to the next slide. Every government of the day coming into power, it comes with a wish list that we are coming to power to implement the following. So I think from South Africa to North, West Africa to Central, you find every government of the day as an intention of ruling. We say we are going to provide the health care, we are going to provide this. And I think sometimes government gets fatigued when you find their wish list is not getting implemented as fast as government wishes. I will give you something which happened in Kenya. Immediately we had our election in 2017. I think the government of the day wanted to bring in some checks on the laws on security. And our Speaker of the National Assembly recalled Parliament, the National Assembly from recess through a gazette notice, which is the normal procedure. Immediately after that, there were some laws which had been gazetted by way of miscellaneous amendments to the security laws, various security laws in Kenya, touching on the terrorism to penal code. They were immediately enacted within a period of, there was a lot of chaos in the chamber, but what happened was the laws were enacted. To cut the long story short, two cases were filed, one by the opposition party and another one by a gentleman called Colloquium. He is the chief litigation counsel for the human rights bodies in Kenya. So they went to court, and the finding by the court, I think, is very startling. One, the trial judge said, the Constitutional Court of Kenya said that although the Speaker has the constitutional mandate to recall the House, he must give an explanation why. It's a decision the Attorney General was never challenged in court, so it is still binding on us. You don't just call. And then the other issue was the way the laws were rushed. Was there adequate public participation? Because the government of the day had promised immediately after election that they are going to put in measures for security to ensure the investors are safe and we undertake our business. So you will see, next slide, please. You see that litigation now has become a very important tool for those speaking about human rights. We had one very important case in Kenya. Immediately we enacted our new constitution and we removed the doctrine of access to courts where you show what is your local standard. Because now when you look at many African constitutions, the Bill of Rights has meant all the rights now justiciable before a court of law, especially a constitutional court. Many government buildings in Kenya had no access by persons living with disability. So what happened was immediately the constitution was enacted. Our friend, of course, Omutata, went to court. He sought the court itself the Supreme Court of Kenya, and he said that it was an hindrance to access by persons with disability to justice because they did not have access. There was no lift first, and the building goes up to 3 floors. The court made a pronouncement on that issue. The court said that any government building, and although this matter was targeting the Supreme Court, the judgment was in rem. It would have applied to anybody, that any government building without access by persons with disability, then that building is in violation of the rights of those people. So I think for beginners, that is critical. Even when you are doing your legislation, what are the issues that you look at that they are mainstreamed? Because these are the issues which are raising litigation. People are fighting for their rights. Many of them, when they lose through public participation in their proposals, they come to court, they bring those challenges, and they raise the following issues. You can move to the next slide. A number of issues which are coming up from many cases coming up from court. One of them is the procedure that you have adopted. It's a very critical issue. How did you undertake public participation? How did your committee conduct its business? So that now it has become very critical. You will see, I think, the famous case, Doctors for Life here in South Africa. It's one of the decisions I've cited there. That it should not just be, I think, what the vice president said. It should not be by the way. It is something that you have to take very seriously. Because some of those submissions, when they end up in court, the court asks, did the committee consider these matters? And where is the finding by the committee on this issue? So that the members of the public are not the lawmakers, but they participate in decision making. That is what many of the cases you will see from my presentation are talking of. And you will see the trend. I think the next slide, please. The next slide shows the scenario in Kenya as per last week. I don't know as per this week, because every week we receive a new case touching either on a bill which has been enacted by the Senate, by the National Assembly, or even from a county assembly. There are some laws from the county assembly which are also being challenged, and then you find that the Attorney General and the Parliament of Kenya is being joined. So I think you can see from the slide there that I think the trend is going up. If you start from 2011, I chose that deliberately because we enacted the Constitution of Kenya in August, specifically on 27th of August 2010. And you can see from 2011, when we removed the bottleneck on access to justice through the Bill of Rights, that anyone now can access the court. You don't need local standard. You don't need to prove that you have been injured personally. You can see, I think, the trend. The trend has grown from 5 cases in 2011, and I think last week, the total cases I was having in my office for 2019 alone were 50. And we have 3 more months to go. So I think you can see the trend. Many of those cases are touching on human rights issues. Many are touching on some legislations, because I think the fear is that implementing them will have a bigger impact to the public. So I think that is something which is important. You can move 2 more slides. Yes, and I think those are the areas. The slides may not be very clear, but the areas of litigation in our jurisdiction, one of the areas is on bills. Any bill now going to court, even a small amendment. There was an amendment introduced in our Merchant Shipping Act, I think 3 months ago. It is an amendment which has been pending in the bill for long, and it was challenged in Mombasa. What the people of Mombasa, which is around 400 kilometers from Nairobi, said was that there was no participation at the coastal region where we have the sea. And that was a very interesting argument. And the judges agreed with that argument. They said, if you are undertaking public participation on an area touching on a specific group, then you need to involve them. So what our parliament has resorted into is we do targeted participation. I don't know what you do in your jurisdiction. That if we are going to affect like doctors, then we identify their association, If we are targeting lawyers, we identify their representatives so that now you will have no complaint. The association which had brought this case is an association which works at the docks in Mombasa at the Kenya Ports Authority. So they were saying they were not involved. And very important, the Vice President mentioned this. Parliament had reduced, understanding under 120, the period of, so that it could fast track the bill. It had reduced the pre-publication period of the bill from 7 days to 3 days. The majority leader requested so that they could commit the bill to committees. And the judges could not agree with that reduction of the period from 7 to 3 days. They said that was not adequate. You needed to allow the bill to go the full period to mature for debate. So the issue on legislation, issues on oversight, we have many cases in Kenya touching on oversight. Many of them, especially by our brothers, some who are here, the counties, the county governments, governors, when they are called by the Senate to come and answer questions, you find they decline and they rush to court immediately. One of the governors comes from my county. I think he was in either Dubai or Australia. And the Senate issued warrants, which they don't have power to arrest anybody, but they issued warrants against the governor. And the governor rushed to court. When he was in Australia, he obtained orders saying his right of the freedom was at risk, because he could not come back to the country, even to attend the Senate summons. So these are very interesting times, and I think we need as legal counsel to come up with what I think was proposed, some model approach. I'm sure some model instruments developed from here could help jurisdictions, because you find many of the constitutional courts, they look at what is happening in South Africa, especially where we borrowed our law heavily. What is happening in Zimbabwe? What is happening in Zambia? What is happening in Ghana? Many of the Commonwealth jurisdictions you find we want to check, our judges want to check, is as this kind of law being considered. I think 6 months ago, Kenya came up with a legislation on digital registration of everyone for their identity card. And that law was challenged in court on discrimination by a number of NGOs and a number of communities. And we checked what was happening internationally. We found in many countries. Sorry, I've come up with this kind of a law, but you find implementation has become a challenge. India is one of the jurisdictions where, although the law was enacted, the Supreme Court said it did not comply with 1, 2, 3. So intervention by courts on various areas has become a challenge. So the other area, I think, where the courts have intervened other than on bills is on the speaker's interpretation of the laws. In some jurisdiction, that is an area of, there's a non-go zone area for the courts. But you find in our courts saying, like the case I just mentioned, where the speaker records the house for a specific debate, the court says he must give an explanation. So that is an area I think we need to check, and I have given a case law on that. The other area is on vetting and approval of state officers, including even ambassadors in our country, where you find that is being challenged in a court of law. On purely compliance, you did not consider this, you did not consider that. The question on powers and privilege, I'm sure this may also sound very startling to some jurisdictions, but the power of parliament to discipline, to control the operation of the house has also been challenged in court, especially where a member says his rights have been violated, like he was sent out of the chamber for a number of days. They claim their constituent rights have been violated. I think these are areas we need to come up with a model approach on how we can deal with them. And then just as I wind up on that area, house procedure and standing orders. In Kenya, we have one provision in the Constitution, and it's also in the Constitution of South Africa. It's in a case I've just cited. You can look at it later. On when you are drafting an amendment on a bill which is going to affect rights, I think in Kenya, Article 24 of the Constitution says you must indicate why you are limiting that right, the extent of limitation. It's the same, I think, in South Africa. We borrowed it word by word. And many of the legal counsel dealing with the bills, you find a law will be challenged and impugned in court just because you did not address that issue, that we are going to limit the right of housing, which is a constitutional right. And you did not address to what extent are we limiting it? What are the justifications? Because the consideration by the courts has been, is this justifiable in an open democratic society? The issue of governance that I think the Vice President raised, openness. So many of these cases are touching, I mentioned, on public participation, the issue of constitutionality. Because the issue of constitutionality can be wide, whether the process which originated or whether the bill, including even the question of quorum. Did the House have quorum when passing the legislation? And you as a legal advisor, I think these are the areas we need to address. So I think we will have opportunity to look at, you can just go through the many other slides, but I will just mention as I wind up the following. Yes, what are the emerging challenges? One of them, I think we are having a very organized civil society in many of the jurisdictions, because some of these, they come up as lobbyists. They contribute even to a kitty to attack several legislations. So they do capacitation to various persons who can now come up with a case, or even if they sue personally. Secondly, there is a lot of mistrust. And I think that is what the Vice President mentioned when he talked about Burkina Faso. What is happening in this chamber? There's a lot of mistrust on the workings of Parliament. That these people met at night, they conspired to pass this law against us. The only thing is we chase them out of town. And many of those legislation, there is one specific case pending in court where I think the litigant is saying that the members of Parliament should refund all the money they have been paid for the time when they are on recess, because they are not doing anything for us. I mean, you can see those challenges. There's a lot of mistrust. When you are on recess, what are you doing? And that comes together with the misunderstanding on the role of a member of Parliament. Because the member of Parliament does not work when in the chamber alone. Even when they go out to look for sponsorships for you, maybe for ambassador, maybe at the ministry, but the members of public don't understand. So I want to wind up by saying the issue of outreach is very important. Parliamentary outreach is very important. There are successes I can mention. One of them is that the legislature, despite many attacks from the public, and of course, the public elects you today and tomorrow they start calling you names. And also by the courts, because some of the pronouncements from courts of law have not been very kind against members of Parliament. Sometimes they don't even understand what members do, the courts themselves, because they don't understand the processes. So I think the parliaments have showed a lot of tenacity in upholding and defending the Constitution. The other thing is that some courts have also exercised a lot of restraint, because not many of these cases which go to court resort to a verdict against a legislation or against the parliament process in generally. So there has been a lot of judicial restraint in some cases, but in some other cases we have had some errant judgment, which maybe when you challenge on a court of law at the Supreme Court, like there was a decision at the Supreme Court recently where the National Assembly and the Senate in Kenya could not agree on the division of revenue bill, the money which goes to the state legislatures, in our case the counties. And that matter was taken to the Supreme Court to stop the national government appropriating its money when the ones going to the counties was pending. And it's a matter which is pending before the Supreme Court for consideration. So I think you can see how fast some of these matters are moving. The role of the media is another success story, because the media has been giving a lot of highlight on some of the legislation and matters pending. So as I conclude, I want to say, I think we need to deepen our engagement with the public. That will reduce a lot of litigation. Engagement with the public, even engagement with the courts, engagement with the other stakeholders in the justice system. And finally, capacitation. Because some of the matters that we defend, especially the litigation counsel, you find, even when you ask for documentation, the clerk will say, no, you know, this matter, it was just a small amendment. I did not keep the minutes. In fact, one I asked, and it was a very important amendment. The committee clerk told me, you know, here we did not have a signed report. So what did you take to the floor? And the report had gone all the way the bill had been enacted. So I think these are areas we need to enhance our interlinkages with the other players in this system, the legislative system so that we can also help each other. Because you can imagine the long process, the bill goes before it becomes law, and then it is nullified because of a process which was not undertaken, or it was undertaken but there is no record on what happened.
Thank you very much, moderator, and Sheriff Sam for doing justice to the subject. When I was told that I was going to discuss a paper prepared by Sheriff Sam, I got a little worried, because when I started out in this journey, Sheriff Sam was one of the first people that I talked to in the journey. However, having had a few minutes to look at the presentation, I will concentrate mainly on slide 10 and slide 11, if they could be put up, please. And if Sheriff Sam caused some fears, one of my roles today is to confirm the fears. That yes, the institutions that we serve are under attack, positively and negatively. And whether they survive or not is dependent on the work that we do. It calls for tact, it calls for hard work. Oh, they haven't put up the slide. 10 and 11. That's the summary of everything. And that's the summary of everything that we deal with each and every day. He's cited a few issues, but one thing I'm certain of is that Africa as a continent is growing in its democracy. And what happens, not only practices are borrowed from everywhere, but also the courts, the decisions of the courts in South Africa are impacting the decisions of the courts in Uganda. They're impacting the decisions of the courts in Kenya. And South Africa, looking at Advocate Zuraya, what I remember is public participation. That's a monster that is eating up everyone. 2 years ago, it was unheard of in Uganda. All we had to do was call a few people, talk to them, and pass the law, write a report, pass the law. Until some intelligent people decided it is time to amend the Constitution to do certain things. And then that was the first time I heard about Doctors for Life, the first time I heard about Robert N. Gakuru, that I had never read before. Time. The consulted must be given adequate time to make a meaningful response, and consulting must be receptive and give, those that are consulting must be receptive and give due consideration to all these. We've got a judge who's become very popular today. He's a judge called Honorable Justice Kakuru. He went as far as putting percentages to what consultation should be. In that decision, very many things were defined. The roles of the Speaker in moderating the House, the roles of the Speaker in maintaining the privilege